Welcome everyone, and it's a real pleasure to have you here tonight. It's going to be a fabulous event. I would like to begin by acknowledging that we meet on the land of Gadigal people, the Eora Nation, and pay my respects to the elders past, present and emerging. I acknowledge any Aboriginal people here in the audience tonight, and by acknowledging country in the Parliament, it will help to continue to break down the barriers and continue to build trust across our communities. It is the place where laws have been made over the years that haven't been, too terrific for Aboriginal communities. So that's something that has been certainly definitely improved over the last couple of years and will improve into the future as well. Look, welcome to tonight's session on Federalism, Borders and the Pandemic. It is the third of our House Talk series, and it's a series of events that we hold both virtually and live, of course, you all are live, organised, as Megan said, by the Education and Engagement team. And we feature different experts and special guests who talk about historical and cultural topics that relate, usually we try and bring it back to the Parliament, the history and the functions of the Parliament and the legislature. Tonight we're in, as Megan said, in the beautiful Legislative Assembly, which is the oldest parliamentary chamber in Australia, in fact. It was built in 1843 to house the Legislative Council, strangely enough, which was established in 1823. In 1856, this chamber was given over to the Legislative Assembly, which sat for the first time on the 22nd of May, 1856, as part of the new bicameral, which means two-house legislature, and has been sitting here ever since. Another prefabricated building was built on the southern side of the building, which is now the place of the Legislative Council. The Legislative Assembly is also known as the Lower House. You would have heard it referred to that. And this area here, you've also probably heard it colloquially called the Bear Pit, because of the often adversarial nature of the nature of question time. And of course, we won't have any of that tonight, will we, Professor Twomey? Our speaker this evening is, as I said, Professor Anne Twomey, Professor of Constitutional Law and Director of Constitutional Reform Unit at the University of Sydney. Professor Twomey is a favourite of the parliamentary community. We shouldn't have favourites, but perhaps Anne is one of our favourites. You should hear her talk with such passion to school kids, comes and talks to our Constitutional Convention most years, and you wouldn't believe the way that year 11 and 12 faces can light up when they hear Anne talk about the Constitution. It really is something quite extraordinary, and I think that you're about to have that experience tonight. Professor Twomey will discuss whether the federal system becomes fractured or did it flourish during the pandemic. She will focus in particular on state border closures. Are they permitted by the Constitution? What did the framers of the Constitution intend, and how has that been affected by High Court interpretation since? One last bit from me. We saw federation in action during COVID and the lockdowns, and Professor Twomey will fill us in more on that story. I am reliably informed that the talk will feature masked men, poisonous snakes, a seized train, a romantic ruse, an angel of death, and an unresolved mystery. Over to you, Professor Twomey.
Thank you very much. Before we get to the very exciting bits, let me just start with a little bit about federalism and a tiny bit about law, and then we'll get to the good stories. So, much has been said in recent times about fractured federalism in Australia during the pandemic. But why? Now, my theory is that journalists just like the alliteration of the phrase fractured federalism, and it also just feeds into the general negative zeitgeist that's been going on in this more recent period. But at least in my view, the reality is that the pandemic actually showed us ways in which the federal system has functioned well, indeed clearly resulting in the saving of thousands of lives. The whole point of a federal system, of course, is to accommodate difference. Federal systems are used in countries which have significant differences amongst their populations, so differences with cultural and linguistic groups. and also in countries that have very large geographical areas like Australia, where people live in different climates and different circumstances. Federal systems allow a country to decide that some things should be treated as uniform in nature, while others should be treated differently in different parts of the country. And this has many advantages. For example, it permits competition and innovation so that we can actually compare and learn from each other. When one state stuffs up and does badly, other states learn not to do that. But if one state succeeds in a form of innovation, in fact, most significant change in Australia does first get done in a state, and other states can see that it's worked well and then adopt it. So that's one of the advantages. Another one is that it moderates exercises of power because no government is all powerful. And that's actually really important to protect the individual, to avoid that from happening. It also means that negotiation is required. So you end up not having extreme outcomes because you have to negotiate down to something more reasonable. Most importantly, federalism allows for things to be done differently to meet the wishes and needs of the people of each state. You wouldn't, for example, use the blueprints of the hospital in Canberra, which was built to cope with snow, in order to build exactly the same hospital in Darwin, where the climate is completely different, and such a building would be utterly ill-suited to the needs of the local Aboriginal population. Except, in fact, they did. And they did that because both places are actually controlled by the Commonwealth, and neither of them are states. And it is a classic example of why one size does not fit all. And we do need states so that we can accommodate different needs and different conditions. Now, this became quite obvious during the pandemic. Some states had COVID circulating and others did not. It would be complete madness for them all to apply the same rules consistently in those circumstances. Some states, by shutting their borders, managed to exclude COVID for a long time. This allowed their businesses to continue to operate. Children were able to stay at school. Cafes and gyms remained open. People were able to socialise without even needing masks, and it also kept the economy ticking over because while some states were stuck in lockdown, other states were still able to function. It was particularly important where those states were involved in our exports like Western Australia. Keeping the mining sector working basically kept Australia financially afloat during the pandemic. So imagine what would have happened if there was no federation, if the Commonwealth alone had been in charge, and there were no borders closed during COVID. COVID would have ripped through the entire country at the same level that we saw in Victoria. Many thousands of people would have died before we even got vaccines, and the economy would have been devastated, particularly if that mining in Western Australia had to stop. There will be many people wandering around today, grumbling about the federal system, who are only alive because of the federal system. Now, the other advantage of federalism during the pandemic was being able to see what worked and what didn't. So if one state did better in hotel quarantine than another, then that other state could learn from it and make changes. If there had been only one level of government, there would have been uniformity, which people often think is a really good thing, but probably it would have been uniformly bad outcomes with no real measures for comparison or example on how to improve. Now, this is not to say that the system worked perfectly. Nothing ever does. There are certainly some areas in which better coordination and uniformity was needed. Things like logistics, for example, in terms of transportation of goods across the country, etc. But on the whole, the federal system saved Australian lives and protected the economy. Now, while some, especially those in the media, criticise state premiers for being parochial and not acting uniformly, in fact, the state premiers were actually doing their job. They were responding to the wishes and needs of the people who elected their governments. That's not fractured federalism. That is a functioning federation. Okay, that's my little rant. Let's get on to border closures. Okay, so one of the most controversial aspects of the pandemic was the closure of state borders. Section 92 of the Constitution, I did tell you there'd be a little bit of law in here, states that interstate trade and commerce and what it describes as intercourse among the states, which is less exciting than you'd think, and is really just the movement of people or animals or goods across state borders, shall be absolutely free. Now, this led many to assert that state borders could not be shut, as there is a constitutionally guaranteed right of people to travel across state borders. The words absolutely free, they said, meant just that and did not permit any restrictions. This, however, was not quite right. It is actually plain from the text of the Constitution, if you read it, putting it in the context of the other provisions in the Constitution, that some restrictions are permitted. The Commonwealth, for example, was given the legislative power to regulate interstate trade and commerce, and also to impose quarantine, which necessarily restricts movements across borders. You can also look at Section 112 of the Constitution, not one that almost anyone knows about, but Section 112 recognises that the states may levy charges for inspection laws that ensure that goods and animals across the border are not diseased. So this whole idea about quarantine and stopping disease from travelling across borders was something that was built into the Constitution. It's also clear from the convention debates of the 1890s and from separate legal opinions by the framers of the Constitution written in the first decade after Federation that absolutely free did not mean absolutely free of any restriction. It was actually directed at being absolutely free from taxes and imposts upon border crossings. That's what they actually meant. So you didn't have to pay taxes on your goods as they crossed the Murray River. Okay. 3 justices of the High Court said in 1928, the establishment of freedom of trade between the states is perhaps the most notable achievement of the Constitution. Yet it would be a strange result if that achievement had stripped the states of power to protect their citizens from the dangers of infectious and contagious diseases, however such dangers may arise. Their Honours concluded that a New South Wales law that prohibited diseased cattle from crossing the border into New South Wales, and which required, in some cases, for those cattle to be destroyed if they entered the state, did not breach Section 92 of the Constitution. And the court, around the same time, took a similar view in relation to diseased potatoes. You'll notice that we didn't put on the flyer the bit about the diseased potatoes and the cattle because we thought you wouldn't come, right? The stories get more exciting after this, but let's just deal with the diseased potatoes first. So a law that banned diseased potatoes from entering a state, the court held was valid, but, and here's the key thing, a law that banned all potatoes from entering the state without checking them, just to exclude the risk of any disease, was considered to be invalid because it was disproportionate. Okay, so in order to get the exception from Section 92, what were the 2 key things you needed? 2 key things that you needed was to have a justification for your law, like protecting public health, and it had to be proportionate to that justification. Okay, this is from the 1920s, 1930s, when the people around were still the people who were, largely involved in federation. Okay, let's get to the more interesting stories. So, we've talked about diseased cattle and diseased potatoes, but what about people? So, could a state shut its borders to prevent people from crossing so that an infectious and deadly disease did not enter the state? Now, this dilemma first arose towards the end of World War I as troops were returning to Australia. When the Spanish flu began to spread in late 1918, Australia had 2 layers of protection. The first was the external border of Australia, and secondly, it was the borders between the states. Now, in relation to the external border, the soldiers who were returning from war were quarantined, first of all in their ships in Sydney Harbour, and then at North Head at the quarantine station. But there was insufficient accommodation at North Head. There were an awful lot of soldiers returning, and so the troops were told they had to come on to the land around the North Head quarantine station and pitch tents there and sleep there. Now, one particular ship, when it arrived, did that and discovered that the entire place was full of poisonous snakes. After having killed 67 poisonous snakes on the first night that we're all getting into their tents, it's probably unsurprising that they mutinied. So, fully masked and in military formation, they marched to the gates of the quarantine station. They defied the guards on duty to shoot them. And unsurprisingly, the guards were not prepared to shoot hardened Australian troops who had risked their lives to defend Australia. And the troops marched out of the quarantine centre, down to the ferry, got on a ferry, went to Circular Quay, and after some negotiations with the government, marched on to the Sydney Cricket Ground, where they managed to camp and serve out their quarantine without snakes. Okay, so that's ticking off masked men and snakes from our list. Okay, second line of protection was state borders. So in November 1918, before Spanish flu came to Australia, an intergovernmental agreement was reached that if a state identified an infection with Spanish flu, it would then notify the Commonwealth immediately. The Commonwealth would then control the state borders, closing the border to neighbouring states until such time as the neighbouring state happened to be infected, and then you'd open the border between the two infected states. All right, that was the plan. Victoria became infected first, but didn't tell. And it wasn't until a doctor who was getting an awful lot of patients with all these types of symptoms dobbed that the Victorians had to admit that it was already there. By that time, a soldier from Victoria had gone into New South Wales and New South Wales was infected. New South Wales immediately did admit that it had Spanish flu, then discovered it had already been breeding in Victoria, and the Victorians hadn't said. New South Wales was furious at that point, slammed the border shut and said, that's it, the intergovernmental agreement is gone, it's every state for itself, we have been betrayed. And after that, the Commonwealth tried to reassert control, but its threats were ignored. The states closed or opened their borders in their own interests. It was 100 years ago, and probably not a lot's changed. Western Australia then seized and impounded the transcontinental train with passengers entering the state, putting all the passengers in quarantine. Actually, they didn't really intend to seize the train. They had put up tents to house the passengers in quarantine, but a massive storm blew through, all the tents blew away, and so they had to quarantine the passengers on the train, whereupon they had to take control of and seize the train. The Commonwealth objected that this breached the intergovernmental agreement and possibly the Constitution, and Western Australia didn't care. There's this marvellous explanation in the Perth newspaper where they said, had we admitted the transcontinental travellers, we might have suffered infection. There was a chance. We preferred to flout authority and break the agreement of November and even perhaps fracture some constitutional statute rather than court the disaster of the entrance within our borders of the Black Plague. You can see their point of view. I mean, basically, if the Constitution was breached, well, too bad, we'll pay for that later, but we'd much rather keep people alive, was the view. Now, the problem with shutting the Western Australian border was that the Western Australian Premier was on the wrong side of it. Henry Lefroy, the Premier, had actually been in Melbourne at an intergovernmental meeting at a Premier's conference and was stuck there because he couldn't get the train home, and they'd also blocked shipping coming into Western Australia. Now, the acting Western Australian Premier, Hal Colbatch, who was also the Health Minister, was the one who shut the border. The Premier and the Prime Minister both petitioned him to reopen the border, to at least let the Premier come home, and he refused. His actions were wildly popular. This might ring a bell. So popular indeed that within a couple of months, Colbatch himself had become the new Premier of Western Australia, despite the fact that he was a member of the upper house. Now, while the Spanish flu did eventually penetrate Western Australia, its delay did actually save many lives. So it was effective. Queensland also shut its borders, including those in border communities, contrary to the agreement. It charged people a considerable amount of money to enter quarantine camps. It required them to receive 2 compulsory vaccinations before they could enter the state. There were all too familiar stories of lockdowns, the closure of schools, disagreements about mask wearing, vaccine mandates, and quack cures. So everything we think was unique in the last few years, sorry, it all happened 100 years ago as well. But despite the controversy, interestingly, nobody brought a constitutional challenge in the High Court to the border closures. So we didn't get any litigation out of it. So the next interesting reason for shutting the borders was World War II. So during World War II, the Commonwealth issued an order under a national security law that prohibited civilians from travelling by train across state borders unless they had a permit. Now, according to the official version of events, and I'll get to the unofficial version later, but according to the official version, Dulce Johnson was a young woman. She was engaged to be married. Her fiancé was in the Navy and he was about to be shipped off to war from his training base in Perth. Poor Dulce might never see him again. So, in October, she applied for a permit to travel from Sydney to Perth, but it was denied. This wasn't an appropriate reason for going. She went anyway. She was a woman of great determination in a last dash to see her beloved before he went off to war. So she managed to buy a series of tickets that somehow got her to Port Augusta in South Australia. Curiously, nobody ever discusses the fact that she moved from New South Wales into South Australia, which was also illegal. But anyway, she gets to Port Augusta and then she stays on the train and she admits to the conductor of the train in South Australia that she has no ticket and no permit to cross the border into Western Australia. The conductor says she has to leave the train at Cook, which is the last stop before the Western Australian border. But when they get to Cook, the station master refuses to let her leave the train because it is not a suitable place for a young lady. So, Dulce made her way to Perth and was prosecuted. She was with another companion. Her companion was also prosecuted and that was fine and done, and she was fined a small amount of money and that was it. Dulce, however, was curiously well resourced and had legal counsel who appeared before the magistrate and argued that the charge, that the law was unconstitutional because it breached section 92 of the Constitution. The magistrate agreed and the charge was dismissed. Now, the media portrayed this as a great love story. Dulce was described as blonde and remarkably beautiful. Headlines said, "Love laughed at rail permits." The Commonwealth, however, was quite concerned that its law about movement of people during the war was held invalid, so it appealed to the High Court, where Dulce was represented for free by 2 of the most illustrious King's Counsel of the time, including Garfield Barwick. It's a long story about why they did that, but anyway, I won't go into that here. Anyway, now this tale might have ended at that point, but when I lectured about this case to my students, I speculated. I just wondered, well, what happened to Dulce? Did she ever get to marry her beloved? Was he killed in the war? I don't know. Then I had a student who was sufficiently interested by that she started doing some research on this. So this is my student Claire Davidson. And she alerted me to what she'd found. So she discovered there was a remarkably beautiful blonde woman who used the name Dulce Johnson, along with many others, because she was a notorious criminal, known in the press as the Angel of Death and the Black Widow. Now, this Dulce Johnson was involved in the Sydney underworld in that period, And according to the press, at least 8 of her husbands or lovers had been gunned down or stabbed to death, and she had more than 100 convictions of her own. In fact, there's a book about Dulce that you can buy, which includes a photo of her being carted out of her house on a stretcher after she had been shot while lying in bed, which is a fairly remarkable thing. Anyway, we know that Dulce did travel to Perth from her East Coast dens of crime, because we do know she was convicted of running a brothel in Perth in 1946. So was this the same Dulce Johnson who had no permit to travel to Perth in October 1944? So as a good academic, I went back and I had a look at the archives on the file about Gratwick and Johnson, the relevant case. And there are 2 interesting red flags. First of all, the records state, numerous places, that proof of Dulce's identity was waived. The inspector simply accepted that that was her name and there was no identity check at all applied. And one does wonder why it was noted so many times in the records that no one actually knew whether she really was Dulce Johnson. Second, in her interview, Dulce actually named her fiancé, who was in the Navy. But if you look at the war records, there is nobody of that name who was in the Navy in Perth at that time, or even any similar names. I did a lot of searching. So the great love story was a ruse. Okay, that's the romantic ruse bit. So, was this instead the story of a gangland figure fleeing her crimes in Sydney to run a brothel in Perth, and then getting the most eminent King's Counsel in the land to represent her for free in the High Court? Perhaps. We don't know for sure. That's the mystery. But what of the law? I know you're all asking yourselves. Well, the High Court accepted in that case that transport is intimately connected with defence, and that the defence power would support a law restricting transport. But this was still subject to Section 92 of the Constitution. If the law had been one that regulated train travel for defence purposes, affecting both travel within a state as well as interstate travel, then it could have been valid. But here, there was no defence justification for why the only restriction was to going across state borders, not to train travel within the state. So the order was held invalid. The Commonwealth Government, interestingly, in some later submissions, which I also found in the archives, was very critical of this decision. It argued that priority needed to be given to military personnel and freight in long-haul transport during the war, and it contended that the law was not really directed at stopping people crossing borders, because you could cross borders in other ways. They pointed out you could do so by walking or on a bicycle, which frankly I don't think you'd be doing between Western Australia and South Australia, but anyway. And they just said, well, it wasn't really about moving across state borders, it was just the fact that the natural place to police long-haul transport was at the state borders, because that's where the infrastructure was. In any event, those complaints were too late. The High Court had already held that the law was invalid. But what if you marked a line within a state and said that you weren't allowed to cross that line, but the effect of doing so meant you couldn't cross the line and therefore get to the border to cross into another jurisdiction? Would that be valid? So in Western Australia, leprosy had begun to spread rapidly in Aboriginal communities in the north of the state, and it grew significantly during the early parts of World War II, partly because the nurses that were there had been withdrawn for defence purposes, and partly because the patrols and all the other sorts of things where that identified people with leprosy had been removed during the war as well. So as a consequence of that, in 1941, a law was enacted to prohibit Aboriginal people who didn't have a permit from crossing from north to south across the 20th parallel, which, if you're looking at a map of Western Australia, is just above where Port Hedland is. Okay? So you couldn't move from north to south. You could go south to north, but because the leprosy was spreading in the north, they didn't want people to move south and spread it downwards. And so this was known colloquially as the leper line in Western Australia. Now the line had the effect of separating Aboriginal communities and preventing those in the north who had poor working conditions from leaving those stations that they were working on for better working conditions south of the line. Now in 1957, an Aboriginal man called Dulce Johnson transported 17 Aboriginal people from stations north of the line to places south of the line. One of those people had leprosy. Now, Dulce was described in court documents as a native lawgiver. It's actually quite interesting that he really was identified in those documents as having a significant legal position within Aboriginal communities. So he was prosecuted, convicted and fined £1 by the magistrate, along with costs of £32, which was significantly more. Anyway, Dulce, like Dulce, was represented by counsel in this case by a fellow called Tom Hughes, who is not the Tom Hughes you're thinking about from New South Wales, different Tom Hughes, who was a former Western Australian politician. And he argued that the law was invalid because it breached Section 92 of the Constitution, because it prevented Aboriginal people from moving south in Western Australia in such a way that they could then move into South Australia. Okay, so it prevented them effectively from crossing state borders. The magistrate rejected the argument and it was appealed to the full court of the Western Australian Supreme Court. There, Hughes again argued his constitutional case. Interestingly, if you read the newspaper reports on Trove, which is a true treasure trove of interesting things, anyway, he told the court that Dulce, as a tribal law carrier, held an equivalent status to the judges and was a brother-in-law of the bench. Now, I don't know how well this went down, but it was clear that the court was not particularly sympathetic to the constitutional arguments made in the case. It's an unreported judgment, by the way. I managed to find it through the archives. It'd be quite hard to find it otherwise. Anyway, and I should say, by the way, I don't think anyone knows about this case, so you're hearing about it for the first time. Chief Justice Dwyer, with whom the rest of the court agreed, found that the law was a reasonable measure to prevent the spread of disease. It prevented the movement of people within a state so that those south of the line would not be exposed to leprosy. He noted that it had not been suggested that Mr. Dulce or any of the Aboriginal people who he moved had been seeking to travel interstate and had been prevented from doing so. He thought the law had, quote, no real effect on intercourse among the states at all. He characterised the law as an exercise of health powers that could not be seen to be an attempt to evade the operation of Section 92. So again, the focus was looking at, well, is there a legitimate reason for these laws, and protecting health and preventing the spread of a dangerous disease was regarded as a legitimate purpose. And then the question would be, well, are these laws proportionate? In that case, they seem to think they were. Now, interestingly, although Dulce lost his appeal, and he didn't appeal further to the High Court, as he'd originally suggested he was, he still actually won the war in this sense. Because what he did in practical terms was he arranged for Aboriginal people in very large numbers to keep moving across this line. So they'd move south across the line illegally, they'd move north again, they'd move south again, and they did so in such a way that it was impossible for the authorities to police it, because their prisons would be full the whole time, they didn't have the capacity to prosecute. He just made the law completely impracticable. The Native Welfare Department, which was in charge of policing the law, concluded that actually the law wasn't really necessary for welfare and it was a waste of their time trying to enforce it. And they then tried to get the Department of Health to get rid of this particular law. The Health Department said, well, leprosy is still a serious problem, so we do need to do something about it, and so they insisted that the law stay. So in the end, what the Native Welfare Department did was that they made sure that Aboriginal people were alerted to the fact that permits would be given to people if they asked. So it was a practical way of getting around the law, and it made it ineffectual. So in the end, the problem was avoided by making permits easily available, and so no one needed to take any action. The leper line was actually finally abolished in 1963. Now, it's probably the case that none of you have ever heard of the leper line. I certainly hadn't until I stumbled across this case by serendipity. But what was also interesting was that in looking at Hansard at the Commonwealth level, the politicians at the time didn't know about it either. So Dooley and MacLeod, who he worked with, had written a letter to Arthur Calwell at the time, complaining about the line. And Arthur Calwell then raised it in the Commonwealth Parliament. And he said, but I should add that Calwell clearly didn't know about the leprosy purposes of the line. He just knew that a line, was told that the line was existed, and it was prejudicial to Aboriginal people. Calwell got up in Parliament and said, well, look, this is absolutely outrageous. No Aboriginal person should be told that they can't move across any particular line. So he raised it. Paul Hasluck, who was the minister at the time, said, well, do you know this line actually exists? Calwell says, well, I've been told it exists by people. I don't have any personal sort of knowledge of it. But what was interesting was that the members of Parliament at the Commonwealth level were absolutely staggered that such a line could exist and clearly didn't know anything about it, which I think is quite fascinating in many ways. It does show how these things were unknown and these sorts of problems were not well ventilated. Anyway, that's the story of the leper line. I just thought that the reason for telling you about that case is it does tell us something about COVID and movement of people and all those sorts of things. So all of this history gives us a good context for what happened when the pandemic hit Australia in 2020. So just as in 1919, states were prepared to close their borders to prevent its spread to them, at least before there were vaccinations available to limit the serious effects of COVID and in order to prevent hospitals from being overwhelmed. Tasmania's Mercury newspaper gave as a headline in March 2020, "We've got a moat and we're not afraid to use it." I have to say, I think that's one of the best headlines ever. I don't think anyone would ever have thought of Bass Strait as a moat, but anyway. And Western Australia, just as it did in 1919, shut its border to keep COVID out, and again was largely successful in doing so. As I said before, the border closure not only protected the mining industry, so from an economic point of view, but also is really important at protecting those vulnerable Aboriginal communities, particularly in the north where Dooley had been and the leprosy line was. Now, the Western Australian border closure, which was again wildly popular, was criticised by the Commonwealth Government, just as it had been in 1919. And this time, however, was challenged in the High Court, as you will remember, by Clive Palmer. Now, Mr. Palmer was refused entry into Western Australia, where he had mining activities and his company was involved in. Mr. Palmer claimed that his physical presence was needed in Western Australia to run his business there. Western Australia said, you can use Zoom like everybody else. Clive didn't take that lying down. Now, as you'll probably remember, the Commonwealth initially supported Mr. Palmer in his application, and then after seeing the political fury that arose in Western Australia, withdrew from the case, but nonetheless the damage had been done. Now, the parties in the case could not actually reach an agreement on the facts in relation to the risk involved in terms of Western Australia and the transmission of COVID-19. So that aspect of the case, the factual aspect, was sent to the Federal Court to determine. Justice Rangier in the Federal Court heard evidence from epidemiologists about the level of risk involved in the spread of COVID-19 and in relation to different measures to prevent its entry into the state. And he determined that a precautionary approach should be taken to protect the community. The state's capacity to provide safe quarantine facilities was limited, and the risk of COVID spreading was high, with potentially catastrophic results if it did. Now, on the basis of Justice Rangier's findings, it could be concluded that the border closure was reasonably necessary for a legitimate purpose and proportionate to that purpose of protecting public health. Unlike the case about the diseased potatoes, there was no ability to know with certainty whether a person entering the state carried COVID-19. And you can test, but the tests aren't going to tell you whether the person's brewing it within them. Same sort of problem actually with the leprosy as well. I mean, you could do inspections at the line, but leprosy has a very long period of gestation within the person before it becomes obvious. And so for those reasons, it wasn't a case similar to the diseased potatoes. Okay, so the High Court then, in its judgment, and I have to say there are many things about the judgment about which if I was giving a legal lecture I would be quite critical, but for a public lecture I won't go into the technicalities of all that. But the High Court held that there was, the High Court reconsidered the test that should apply as to whether a law breaches Section 92. It looked to whether a law discriminates against interstate trade or movement of people. In this case, clearly the law did. It didn't just discriminate against you moving across state borders. It stopped a lot of people from being able to move across. Not everybody, some people were allowed, but for the most part it restricted movement. So it certainly breached that aspect of it. But second, the court looked at whether there was a legitimate purpose for the law and whether it was proportionate to achieving that purpose. So in this case, the High Court held that there was a legitimate purpose of protecting public health and that the law was proportionate to achieving it. It looked at the emergency law that this was done under and said, well, look, there are inbuilt restrictions on the use of emergency powers in Western Australia. They could be exercised for the purpose of managing the adverse effects of, they could only be exercised for the purpose of managing the adverse effect of a declared emergency, and an emergency itself could only be declared where extraordinary measures were required to minimise loss of life and harm to health. If the powers had been exercised for other purposes, such as political purposes, i.e. we just don't like the people east of, the state and therefore we're not going to let them in, if it had been for those purposes, then the law would have been invalid. But the court considered that was not the case here. Chief Justice Kiefel and Justice Keane said, it may be accepted that the restrictions are severe, but it cannot be denied that the importance of the protection of health and life amply justifies the severity of the measures. Now, while the terminology has differed over the years, when the High Court has addressed these cases, all of the examples that I have described lead to the same conclusion. Section 92 is not absolute. The interstate movement of people may be restricted, but only if there's a legitimate purpose, such as protecting public health and safety, and only if the law is proportionate to achieve that legitimate purpose. For that reason, both Clive Palmer and the Western Australian Premier of 1919, Henry Lefroy, were excluded from entering into Western Australia. Dooley was limited in his movements within Western Australia, but found a way around it in practice. Dulce, however, was the most successful, freely entering Western Australia. Dulce was more than just a pretty face, but whether or not she was also a notorious criminal remains a mystery. Thank you.
Okay, we've only made one mistake tonight. This is the Legislative Assembly. There are 368 rules in here, and one of them is you're not allowed to clap. But anyway, have another go, please. That was extraordinary and entertaining and extremely insightful. So I love the idea of fractured federalism being just something that, journalists like the alliteration, that's cool. But more importantly, I just want to review with you tonight Masked Men, Poisonous Snakes, Seized Train, Romantic Roofs, An Angel of Death and an Unresolved Mystery. You hit every one. You are really good. To me, Section 92 will never be the same again. It's not absolute, that it has to have a legitimate purpose, and it needs to be a proportionate response. So, am I doing well? Thank you. I always wanted to do law. Wouldn't you love to be taught by this person? Okay, so no government is all powerful, we know that. It's been proven. How did we survive? Pretty well. I'm loving Dulce. I'm going to be reading more about her, and the fact that you put Clive Palmer and Lefroy together just excites me. Okay, so I know you've got questions, because I certainly have. And what I would like you to do, so just keeping in mind the camera up there, you might not want to appear in it, if you could just speak as loudly as you can, because then we'll capture your question on camera, and if you're not loud enough, I'll be repeating the question, or Anne, you might like to repeat it with a signal from Remy Brand. Okay, questions, please. Yes?
During the pandemic, there was a lot of argument about quarantine. So who has the ultimate power of quarantine? Is it, as you said, the Commonwealth during the war, putting the people in the quarantine station, or is it the state that has the right to set up quarantine facilities, for example?
Yep. No, really good question. And for anyone who wants more details about that, I actually wrote a little piece on it in the Australian Law Journal, if anyone wants to look it up. So the answer is both. So it was always intended, Constitution gives to the Commonwealth Parliament power to make laws with respect to quarantine. So that's expressly in there. But it was also always expected that the states would still keep their own quarantine laws up until such time as they might be in conflict with the Commonwealth. So long as the state quarantine laws and the Commonwealth's ones could work in parallel together and not conflict, then that was all okay. So the Commonwealth largely focused on the external borders, trying to stop disease coming in, and the states focused on quarantine in terms of their own borders, and movement across and all that sort of thing. The Commonwealth, however, did then take over the state quarantine facilities like North Head, right? And so all the places that we had for human beings to quarantine, which again were directed at the external borders, they were directed at ships coming in, right? So that's why North Head is where it is. And so the Commonwealth took all of those facilities over. And then, unfortunately, decided to get rid of them or flog them off around the 1980s, when they decided that, this wasn't really an issue anymore. We have vaccines and we're never going to need to quarantine people again. Massive fail. So that was problematic because it removed the capacities of the states to deal with these sorts of things. So when we actually came to the point where we did need to quarantine people, the Commonwealth wasn't taking any action in terms of quarantining people coming to the country. They did initially. So if you look at the very early stages where they brought flights of people back from China and they quarantined them in Howard Springs, and then you might remember the Diamond Princess in Japan, they brought people back from there and they quarantined them. So the Commonwealth did initially, but then it just collapsed and gave up, right? And it was you go back and have a look, there are a lot of letters in the newspaper saying, well, look, I've just come back from Singapore or whatever, and, in the airport there were all these restrictions, and then I just waltzed through in Sydney and no one was stopping me or taking my temperature or doing anything, what's going on? And it was actually the states, in the end, through National Cabinet, that went to the Commonwealth and said, for heaven's sake, you need to do something, and if you're not going to do something, we will do something. So the states in the end took over hotel quarantine, and they volunteered to do that simply because there was a gap that the Commonwealth wasn't filling. And that in itself is another advantage of federalism. If one level of government fails to act, you've at least got someone who can come in and fill the gap. And that's what happened. Now, admittedly, they didn't all do it very well. There were obviously real problems, and particularly in Victoria, but in terms of the capacity to do it and the facilities, remember, because they'd flogged off all the quarantine stations, the only capacity to do this was hiring hotels to do it, right? And Commonwealth could have done that just as much as the states. There was nothing particularly statish that meant that the states had to do it. The Commonwealth's excuse, if you ever ask them about this, is, oh, well, states run hospitals, so, you know, if people got sick, that would be a problem. And you're thinking, oh, for heaven's sake, if people got sick in hotel quarantine, you don't think you could transfer them to a state hospital? I mean, really, if you were the Commonwealth and were running hotel quarantine, that's just a completely lame argument. It was just a pure failure of will, capacity, I don't know what, at the Commonwealth level, but they just weren't capable of doing it, and the states stepped in. But in terms of power, they both have power, both the Commonwealth and the states, and so long as the laws don't conflict, then they can continue to operate in parallel.
So, 2 questions. At the back first.
Professor Twomey, as I understand it, do people's health more important than their rights?
Yeah.
What you said about
Okay, so that's an interesting question because these are all rights, so a right to life, for example, as well as rights of freedom of movement and all those sorts of things. So it is true that the courts in the end, when looking at the issue of is there a legitimate purpose and what is the seriousness or significance of that purpose when compared to restrictions on rights, they did look at that in the terms of proportionality. And I think it's fair to say that the courts, in a lot of these cases, because there was a huge number of cases that went through about freedom of movement and other things, the courts did favour collective rights over individual rights. So the collective rights to people's health were given priority over individual rights of movement. And a lot of that is inconsistent with, you know, the people protesting, the libertarians, took a more individualistic view of rights. You know, this is my right to move and go where I like and you shouldn't restrict it. Whereas the courts tended to support more the collective rights of the people, that, well, your individual right can actually harm other people and therefore we need to take a more collective approach. Now, is there anything in the Constitution that requires that? No, there isn't. So that was just simply the way the courts tended to interpret it, but it was actually pretty consistently done, so it wasn't just the High Court. You could see similar approach taken in the Federal Court and also in state Supreme Courts. So overall priority was given to public health collectively over individual rights.
Okay, we've got time for one more.
Do you see the way that the foot and mouth is coming in? It seems to be following the same sort of delayed path and slow to react. Where will we end up?
Well, it's one of those things, you'd think that we'd be getting a bit more nimble and better at dealing with these things. I think one issue is going to be that because there's been a very recent change of government, it's actually quite hard for a new government to be able to instantly deal with things where they're still filling off positions in their offices and all the rest of it. So from that point of view, it's pretty bad from a timing point of view. But yes, I mean, in terms of foot and mouth disease, that's definitely more Commonwealth responsibility because all the biosecurity legislation about disease coming into Australia has traditionally always been done by the Commonwealth, so that the customs people at the border, etc., were all Commonwealth bodies. So it really is a role for the Commonwealth to deal with that. Now, it might well be that at some point states also need to play a role in this. Say, for example, foot and mouth disease comes into Queensland, for example, then it might well be that some restrictions are put on the border to stop it from spreading into other jurisdictions. I mean, we've seen that cooperatively with the Varroa mite in relation to the bees, for example. I mean, you know, none of this should be seen to be so much state parochialism. It helps us all if some parts of the country are protected from disease spreading. So, you know, on the one hand, people say, oh, you're being mean by shutting your borders or whatever, but actually, if you can contain and stop diseases from spreading through the rest of the country, that's really important for Australian agriculture and all those sorts of things as well. So it may well be that the states end up having to play some role in this, and again, federalism is helpful there, but one would hope that the Commonwealth has good measures in place for quarantine, because frankly they've been practicing for this for a very long time. Unlike the pandemic stuff where they'd thought, now it's never going to happen, the keeping disease out from animals and stuff, they've been doing a lot of work on that for a long time. So if they're going to get anything right, that's the one they should probably get right.
Okay, I'm going to allow you to do it again. And that was absolutely wonderful. Thank you. And to be in a lecture room with Anne, wouldn't it be fabulous? So I just want to do two things. I want to thank you for coming. It's, extraordinary times. I'll thank Anne again, and Julie. Julie, can you stand up here for a minute? So I just want to, I want you to come here. So you may not come into this space again. This is the oldest legislature in the country. Press gallery. Over here is Hansard.
And one of our lovely Hansard reporters here.
Oh, excellent. Hey. 1863, you go, Hansard goes back to? Yes. Something like that in Australia, way back further in England. W.C. Wentworth, what would he be thinking about this today? Extraordinary. Up here where Remy Brand is that the new Cooper Gallery?
I believe so.
So that's named after the first Speaker of the Legislative Assembly. Public gallery above, Heartbreak City up there. The Ladies Gallery, should you ever wish to go up there by yourself, but you have to be a single lady. I think they've also got another name for that now, the North Gallery or something. Okay, so I just wanted to do that because, as you know, take these opportunities. This is where the Speaker sits. The Premier's about there. Reginald, about there, or the next one. So that's a great seat. Look around, these are where the people making decisions for us are sitting. Now, I just want to show you one of these on every seat to find out about other programs coming up. It's really cool. You just have to see this little thing here, the QR code, you hold your phone over it, and then you sign up for an e-newsletter which tells you the new programs coming up. Now, the one that's coming up next is going to be extremely fabulous, but it's going to have a very limited number of people being able to do this. And it's going to be during History Week, and it will involve a very, very special behind-the-scenes tour on Wednesday, September 8. So numbers are going to be very limited. Keep an eye on the website, sign up, and you'll be the first people to be able to come in. I think that's it. I think that's it. Once again, thank you. Oh, yes.
Is the library still a library?
Oh, no. But if you come on the 8th, you'll see the new library, which is actually one of the oldest libraries in Australia. Okay? It's actually right down, not under us, but under the building behind us. So what you'll see on that night, you won't see it any other time, because we're going to bring items and artefacts out of the archives and show you sort of the secret rooms, special rooms. Okay, yes?
The film goes to go out on the web?
Yes, it is. So that will go on the front page of our website. We'll put a notice up there. Now, there's one last thing I want to tell you. I'll send you an email too when that film goes up. I'm going to send you a SurveyMonkey link tomorrow just to give us some feedback, because we're interested in continual improvement and we particularly want to know what you would like us to be presenting for you. So it's been lovely having you here. Thank you very much, and thank you, Anne.